Again, with Caddo District Court Judge Scott Crichton for the state of Louisiana, Tom Pace on the Talk of the Town. As we look at the Casey Anthony trial and subsequent verdict of not guilty. Now, we're talking about these 12 jurors, and the other thing that they have to feel, you're asking to deal with somebody's life. It's not like, as you said, where she might have gotten just the death penalty. I mean, she would have gotten a second degree and life imprisonment. They're looking at her life. Are they looking at this? Obviously, they took this very seriously.
Well, obviously they did. And let's keep in mind, they had benefit of the evidence that was admitted at trial. We had benefit of all the other business that took place in the courtroom outside of their presence, so we know a little bit more than them on some things. We also had the benefit of all the analysts night after night discussing this matter and this case, and so therefore our information may be a little bit different from their information. Nevertheless, my viewpoint is that that was strong evidence, and I was stunned, as I pointed out, with the verdict. As I reflect more on it after about 24 hours, my viewpoint has changed a little bit. I respect the jury system. I've had too many jury trials as a lawyer or as a judge to feel like this verdict impugns the jury system. 99% of the time, jurors make the right call based on the evidence. And I'm not suggesting necessarily that they made the wrong call. I differ. I have a different opinion about it than they do. My opinion does not matter. Their opinion does matter. I do think the decision weighed heavily on them. And you have to keep in mind that this was a peculiar case, a family that was, I think, extremely dysfunctional. I mean, the dysfunctionality was abundant with this family. One thing that was clear was this young woman is very disturbed in terms of all of the pathological lying that she did time after time. But I think the jury has to take all that into consideration, and some members of the family and some of the people around the family seemed odd, at the very least odd and suspicious, and that might have entered into the reasonable doubt business. But the jury's got to be convinced. They must be convinced beyond a reasonable doubt that the defendant's guilty as charged or guilty of a lesser verdict, and they've got to have confidence in the verdict.
The defense attorney, Baez, kept diverting their attention to other issues. Oh, she could have drowned in a swimming pool. The father discovered it. They knew about it. There were allegations. It is not up to the defense to prove that. It's up to the prosecution to disprove it. Is that right?
Well, the DA is obligated to prove all of what he charges, and the defense should not, in my view, make an opening statement and not present any evidence to back it up. We saw no evidence of what Mr. Baez talked about in his opening statement. No indication in terms of evidence that this young woman was molested as a child. There was no evidence that this child, this victim, drowned in the pool. None, not a scintilla of it. He made an opening statement. He presented no evidence to support what he claimed, and in my view, that's inappropriate. A defense lawyer should not make a claim in an opening statement that he cannot back up with evidence.
So you look at this, Judge Crichton. Was it a win for the defense in that they got not guilty? That doesn't mean innocent now. That means not guilty, and she cannot be tried again for this crime in the state of Florida. Is that correct?
That is correct. She cannot be tried again for the crime of murder in the state of Florida. It's over in terms of any state prosecution. Now, this woman will have a tough time the rest of her life, I suspect, and notwithstanding the possibility of a book deal, which she can do, notwithstanding a made-for-TV movie, which she may be paid for, who knows, notwithstanding all of that, I think her life is going to be troubled. But I think the DA's office in Florida lost the case. I'm not so sure justice was served. However, again, I find no fault with the jurors. They gave up 6 weeks of their lives. They heard the evidence. They made a call based on that evidence, and that's what matters. I still have faith in the jury system as I have. I have lived by that as a prosecutor, and I have lived by that as a judge. And after 400 or 500 jury trials, I can tell you that 99% of the time they struggle with their decisions and they make the right decision. I rarely disagree with the jury in Caddo Parish. I agreed with it. I disagreed with this Anthony verdict, but again, it's not up to me.